up, and she's going to take it away from there. Okay, so if you can just, you can move your cursor, with the arrows here, right here, and
okay, I'll put it in the slideshow view.
I
don't know what they see versus what I see.
Yeah, I think you can leave it there if you like. And we got you ready.
All right. Hello, everyone. My name is Stormy Clark. I'm an attorney with the Earl Carl Institute, and I'm here to give you a presentation on Evictions 101, everything you should know, everything you need to know, to go ahead and be able to represent yourself, or maybe even to share the knowledge and help a friend, help a colleague. And so without further ado, here we go. This is just my contact information. That is my office number, our fax, and the email, as well as the website to where you can go and apply for legal services. And then I also have like a presentation roadmap, because like anything in life, if you don't know where you're going or how you're going to get there, if you don't know the destination, it's kind of difficult to take the journey. So I actually start off with like a eviction knowledge test. I'm not for sure how interactive. Can I respond or not really? Okay, well, I'm actually going to skip the eviction knowledge test, or just tell you just the questions, since it's in a platform where you can't really respond. We have the important terms and time frame in the eviction process, the things you need to know regarding procedure, definitions, grounds, defenses, next steps. We also have state and federal protections, as well as like a little bit of information about self-help evictions and some of the remedies available to tenants, and then some of the available rental sources, rental assistance resources, and just recommendations and best practice. So to speak. And so with an eviction, questions that we have here, so what's an eviction? Whether it's a lawsuit to dispute the amount of rent, the lawsuit to determine superior title to real property, a lawsuit to determine superior ownership of real property, or a lawsuit to determine superior title and ownership of real property and dispute the amount of time. You can just be honest with yourself and see how much you know regarding the answer, or what you think the answer might be. If you guess C, you are correct. You'll hear me say like possession, like a million times throughout this presentation, because the only issue to be resolved in an eviction case or a forcible detainer action is going to be the right to immediate possession of the property. There's some case law and just the elements, and we'll get into all of that later, but just know possession is the name of the game. Now with this one, we also have how many days does Texas law state that a tenant is entitled to prior to the landlord starting the eviction process. Then we have 30 days, 3 days, 1 day, or 7 days. Again, you can just be honest with yourself.
Excuse me. I'm sorry.
You are right now.
Hello?
And if you guess B, 3 days, you will be correct. But it's important to know that you need to read your lease agreement to know what the applicable standard might be, because it could be shorter, it could be longer. Everything with evictions is going to be based in statute, or it's going to be based in contract, which is your lease agreement. Then we have like a true or false question, just because it's an issue I see that happens more frequently now, is that based on Texas law, true or false, when a landlord delivers the notice to vacate to the tenant, the landlord is allowed to email the notice to vacate to the tenant. Again, honest with yourself, see if you know the answer, if you think you know the answer, because the correct answer is false. We'll get more into the weeds of what the law says, but just know that the law does prescribe or like detail the methods for delivering notice to vacate, and that can be in person, it can be by mail to the premises, you can personally deliver it to the tenant or anyone residing at the property over the age of 16, or you can use alternative service. But important to know that email is not part of that list. I think this might be the last question, another true or false. So when a landlord files an eviction lawsuit against the tenant can file a counterclaim, which means like a lawsuit in response or a lawsuit against their landlord for damages to the property. And again, last question, be honest with yourself. If you know the answer, great. If not, you'll learn. And in this situation, the correct answer is going to be false. Texas law does state that the only issue to be determined is the right to actual possession and not title. And then we have counterclaims and the joinder of suits against third parties are not permitted.
They said that somehow they're not, can't see the PowerPoint advance. Hold on a second.
Uh-oh.
So,
So
usually when I go share, right? So I go share, and it usually, let's see.
So maybe that if I leave it in the other view, if they can see it. Well, not putting it in slideshow view, but just like a open window.
Let's see. Go share. I don't know what's going on with this thing. Sorry for the technical stuff, folks, because sometimes this happens. I'm not sure what's going on. Hold on a sec.
Is it currently sharing the screen that you're on?
This says we can't display your shared content. Make sure you've allowed permission to share content.
Does sharing an application work?
I just try.
Well, I guess it's not really an application.
I've done this a million times. I don't know why it's totally different.
Wish I knew more about this program.
Uh, I really don't know what to do. I can't get it to work right.
Does it, I wonder if it's not PowerPoint have permissions on it or something? I think it does.
Huh?
That's the issue. Guess I can just email the PowerPoint and just kind of talk.
That's
I don't know how beneficial it is.
I mean, I don't know if you can just. I'm sorry for the issues. I don't know what's going on. I've used this 50 times, and it's never done this before.
I was trying to think the issues with the screen being shared. I could potentially, I have my laptop. Trying to move it up to the screen may not be the most steady though.
I can't even get. I mean, folks, I guess about the only thing I can think to do is just have her lecture without the PowerPoint, and then send you all the PowerPoint. You know, I know she's well versed in evictions. I don't know if that'll be, you know, practical for y'all, but we can give it a whirl if y'all are up for that. I apologize for the mistakes. I've used WebEx 100 times and can't quite figure out what's going wrong here right now. So I don't want to take more and more time trying to do that. And so why not just let Ms. Clark go on and give a bit of a presentation about how eviction works, just from a lecture standpoint, and I'll send y'all a copy of the PowerPoint afterwards. So is that okay?
Yeah, that's fine.
Okay.
I'll use the PowerPoint to guide it, but I won't
Well,
necessarily
I don't
like.
even know if we can look at the PowerPoint at the same time. So
Oh, so if I'm looking at the PowerPoint, will I still be visible?
no, that's the problem.
Oh, okay. Well, let me just.
I couldn't get it to share screen. That's the whole thing. I can't get it to share screen.
No, I'm okay with it not being shared, just to use it as a guide.
I mean, I can't. Well, I guess I don't know how to do that.
No, like how you're like on the screen right now.
Okay.
If you open up the screen,
Yeah.
but you're still visible on the.
Yeah,
WebEx?
on the camera. You're right. You're right.
Yes, I was like, I can do it that
Yeah,
way, kind of
yeah,
as a
just-
guide.
yeah.
But not necessarily like teach verbatim from it.
that, more just yeah.
Okay, so I'll do my best to present in a way that is user friendly, knowing that you don't necessarily see what I see in the process. But one thing about the eviction process, like from a tenant's perspective, is that it moves really fast. Like it's a fast process, it's a short turnaround. And if you don't know your rights, if you don't know the correct terminology, if you don't know like which words to use, you can find yourself evicted and with a judgment and all sorts of other negative, like adverse consequences really quick. So one thing I like to talk about is like important terms. So we know eviction as eviction, but the legal definition, there's like a forcible detainer. And the forcible detainer, eviction, it just means that basically your landlord has given you written notice that your right to reside at the property has ended. There's different types of tenants where if you're in a lease agreement, you're just a tenant. You have holdover tenants where you had a lease agreement that has since expired, but you're still remaining at the property. So you had a right to be there initially, but then you didn't. You might also see it referred to as like a tenancy at sufferance. Other important terms that we're going to be mindful of is the notice to quit or vacate. It's kind of like a stylistic thing. More than likely, you'll see it referred to as a notice to vacate. The notice to vacate is going to come from your landlord. It's not going to come from anybody else. Your landlord has to give you this notice. It can be delivered in a certain way that's described by law, but notice to vacate comes first. And another important term that you want to keep in mind is a writ of possession. So the writ of possession is the very last step in an eviction lawsuit, and that's after a judgment's entered, that's after the appeal deadline, or if you lost the appeal, it's the very last step to regain possession of the property. Important to note with these eviction cases, only two people or two entities can remove a tenant from the property. That's you if you voluntarily vacate, or law enforcement. If you never leave, and if law enforcement never shows up to remove you from the property, no one else can remove you. So that writ of possession is also an important term. The time frame with the evictions that you want to know about is first step, kind of keep it as kind of succinct as simple. as possible. Step 1 is going to be that written notice to vacate. It's going to say, hey, tenant, you defaulted on the lease, you didn't pay your rent, you have an unauthorized occupant, you have an unauthorized pet, there's criminal activity, whatever the reason is, it's going to be probably told you notice to vacate. One thing to keep in mind with the notice to vacate is there's not a requirement that they tell you the grounds for the eviction or the grounds to vacate, but that you can say, hey, you violated your lease agreement in some way. So don't be alarmed or surprised if the notice to vacate just has some generic language that says you have to leave in 3 days. The landlord cannot file the eviction until that notice to vacate is delivered, until that period or that notice period has expired. So if you got a 3-day notice to vacate and they file the eviction on day 2, it's not proper. They have to wait to the expiration of that 3rd day and then they file the eviction. There is a federal protection in the CARES Act. I think it's like coronavirus, aid relief, and economic. I don't even know what the S means at this point, but I know it is CARES Act. And it does say that for properties that have a federally backed mortgage, which means that the property got money from the federal government when they secured that property, bought it. The federal government says if you're a tenant residing at a property covered by the CARES Act, or if you're at a property that has the Section 8 voucher, a project-based housing, or any other type of government subsidy, whether it be USDA rural, any type of government funding that was used to secure that property, you're entitled to a 30-day notice to vacate rather than a 3-day notice. But all of that's going to be hashed out, or should be hashed out in step 1, which is notice to vacate. You as the tenant have nothing to do with this process. It's all on the landlord. All you do is kick up your feet and sit back and watch to see if they do it correctly. Step 2, we're going to file the eviction lawsuit. Well, not we, but the landlord's going to file the eviction lawsuit. When the eviction lawsuit is filed, the hearing for that lawsuit cannot take place for at least 10 days after the petition is filed. So here, very short timeline. Notice to vacate is going to be 3 days. On that 4th day, let's just say the landlord files the eviction. The hearing can be as soon as 10 days from the date that eviction is filed. Well, really on that 11th day. So we're talking less than 2 weeks here. Typically, it doesn't happen quite that fast. It's usually going to be within like a 3-week window, which isn't much better, but that's how quickly this process moves. Step 3, kind of between step 2 and step 3, the tenant, you are going to receive that eviction citation from the constable or other law enforcement, could be the sheriff, depends on which county what kind of county you live in, with which law enforcement officer is going to come out. That eviction citation is going to come from law enforcement, and it's going to say, you have been sued, you have been served, you have court on this date. Whatever date is in that citation, if the date that you are set for trial, that is the date. There's no continuances, there's no second chances, there's nothing else. That is your court date, and you need to make arrangements to be there for that court date and prepare to move forward with trial. You can't come to court on the date saying, by the way, judge, I forgot my documentation, or I have this paperwork at the house, because it's not going to be heard. So that eviction citation, which comes between step 2 and 3, is going to be your notice of the lawsuit. Step 3 is going to be the trial. At the trial, there's going to be a judgment entered. One way or the other, the landlord's going to win or the tenant's going to win. With these eviction cases, it's important to know that even when a tenant does win, it's typically a hollow victory. It's a small battle to kind of buy time, or put yourself in a better bargaining position or negotiation power, because the way that Texas law is written, there's no way for a tenant to ultimately prevail in the end. If the landlord doesn't get it right the first time, they can file as many evictions as it takes for them to do it properly and to remove the tenant from the property. So with that judgment phrase, you as a tenant, if there's a few different options, judgment's entered in favor of the landlord, and we have the option to do nothing, which means that you don't appeal, you don't move, you do nothing. At that point, if the landlord requests a writ of possession, then they're able to do so on that 6th day after the date of the judgment. And that's where law enforcement's going to come out. They've been notified, they've been given authority to come out to that property and remove you and your belongings from the property. As long as it's not snowing, which doesn't really happen in this area, or raining, or any type of inclement weather, it's going to be a 24-hour notice to vacate. If that notice says they're going to come back at 2 p.m. on October 1st and you're still there, they will execute the writ of possession. They're not required to store your property. They're not required to bag it up nicely. They're not required to box it. They will literally place it on the public sidewalk in front of the property change the locks and get possession of the property back to the landlord. So you don't want to do nothing in this process because you don't want your belongings, you don't want anything damaged, you don't want anything stolen, you don't want your property abandoned. We don't want your property to be mishandled in this process. The other option after the judgment is you can work it out with your landlord. Because even though you have a judgment, it doesn't mean that even though a judgment is entered, it doesn't mean that a writ of possession will necessarily be the next step. If you have a judgment and the landlord never requests a writ of possession, you just have an eviction judgment, but you're still going to be in possession of that property. There's nobody that can remove you from the property except yourself and law enforcement. Law enforcement's never going to show up unless the landlord pays the fee for the writ of possession, and then the judge tells law enforcement to go out there. We're kind of in the world where nobody does anything for free, including law enforcement. So if the landlord doesn't pay for it, nobody ever shows up. Unfortunately, you have an eviction judgment, but fortunately, you're still in possession of the property. With that writ of possession, it can be executed at any point 60 days after the judgment's entered. So you want to keep that in mind, that if you're going to work something out with your landlord, maybe a payment agreement or something like that, you want to try to get it in writing. You want to try to do what you can to communicate as best as you can. Third option, which is a fan favorite for myself, we appeal. I don't like the judgment from the justice court. I don't feel like they followed the law. I feel like I have a defense. I feel like I have some type of legal argument. Tenant has 5 days from the date of judgment to appeal. So don't get confused with any other type of case because evictions they're special. A normal case, the appeal deadline might be 30 days and you might be able to extend it, or you might have other options that you can exercise. Eviction world special. So you have 5 days, which isn't a lot of time, and that's including like 5 calendar days. So it's not 5 business days, it's not 5 holidays. You don't, if the 5th day falls on a holiday, which sometimes it does, your eviction appeal is going to be due the next day. Step 4 in this process is going to be, if you appeal, we go to court, you get a brand new trial, I guess downtown, figuratively, because that's usually where like the courthouse is for the big counties. You get a brand new trial at the county court. This trial can't take place for at least 8 days after the case is appealed. Usually with the court's docket, it's probably not going to be set for at least a month, just because there's other cases being appealed before you. But with the appeal, just know that everything that happened in the justice court is as if it never happened. So you're starting over, brand new trial, brand new evidence, brand new opportunity to present your case in front of a judge. And at this point, because the case is in the county court, there's going to be other rules that apply. So the rules of civil procedure are going to attach. The rules of evidence are going to attach. You can't just say things, or you just can't present documents. You're going to have to lay the foundation, is what it's called, lay the foundation to try to get documents admitted into evidence. If you don't have an attorney at this point, it's highly, highly recommended that you either ask one from the judge or you seek out legal counsel, because there's a lot of times that tenants try to go pro se at this point and they're not able to succeed because they're not able to get their documents entered into evidence. And that's part of just half the battle of being an attorney, is just being able to get the documents in front of to be considered. Even though you have it on paper, if it's not entered into evidence, it doesn't exist. The court can't consider it. Now, step 5, regardless of the outcome after the county court appeal, the tenant does have the right to appeal to the Court of Appeals. Typically, most tenants don't, or most tenants can't, because at this point, now you have to post what's called a supersedious bond. A supersedious bond is usually going to be 10 times the monthly rent. So if your rent's $1,000, supersedious bond is going to be 10 times that. If your rent's $1,500, 10 times that. You can try to get it reduced, but the supersedious bond typically has to be posted within 10 days of the judgment from the county court. By the time you get to that point, you might be tapped on resources. You might not want to stay at the property. It might not be habitable. So just know that you do have the right to appeal from the county court case, but you do have to be in possession of the property throughout the pendency, throughout the whole appeal in the county court. To the Court of Appeals. So that part can get a little tricky, but at that point, you for sure want to have an attorney, because now you're dealing with appellate law, and most attorneys don't even handle appellate law. So you want to find somebody that's knowledgeable, reach out to legal aid, and get that assistance. Now, let's just say, aside from the Court of Appeals option, the last step in any eviction case is going to be that writ of possession. Once there's a final judgment, whether it be the justice court, the county court, the Court of Appeals, the landlord has to ask the judge for a writ of possession. If the landlord doesn't ask for it, that's kind of the name of the game when we with these courts. If you don't ask for it, they can't give it to you. So they have to ask for that writ of possession. The constable's going to come out. They're going to post a 24-hour notice on the door. If you don't vacate before that 24-hour notice, then they're going to execute the writ, which means they're going to put your stuff outside. This is a dangerous position to be in as a tenant because now you're potentially going to be trespassed. You could be arrested. Your stuff's going to be abandoned. There's going to be nobody to protect it. But that's kind of like the time frame of the steps in the eviction process, kind of in a nutshell, just to give you an idea of like what we're working with. So there's not a lot of protections. There's not a lot of time. So we want to make the best use of our time. When you're talking about evictions, I know you can't see my PowerPoint or we're just talking, but there's a few different areas that we look at for the law in eviction cases. Texas Property Code is going to be one area. It's going to be Chapter 24, Chapter 91, and Chapter 92. We also have the Texas Rule of Civil Procedure. So that kind of governs how the court operates, like the petition, who's the proper plaintiff, who's the proper defendant, what the petition has to have, just different things that are like procedural. So that's going to be the Texas Rule of Civil Procedure. You're going to also have your lease agreement. So we don't want to forget about that. Your lease agreement is the contract. When I speak with tenants, 9 times out of 10, I will ask them about their lease agreement. They may or may not have a copy, but I can almost bet that if it's an apartment, it's going to be a TAA lease, the Texas Apartment Association lease. So it's going to be that like 8.5, I think it's like by 14, because it's a little bit longer than the regular page with the red subtitles, because that's what most apartments use. That lease agreement has at least 8 pages to it, and most tenants can only tell me like their name, the amount of rent, and when their lease ends. But like 8 pages of this contract, you have signed all sorts of things that you've kind of waived or things that you've agreed to that is part of the contract. And so it's hard for you to come back later in court, 2 months later, 6 months later, 2 years later, arguing about the contract that you've signed and renewed time and time again that says, oh, by the way, like if it's a TAA lease, I know for a fact it has a provision that says tenants, you're entitled to a 24-hour notice to vacate when you violate the lease agreement. Or it has language in that contract that says at the very end, usually towards on the last page, that says, hey, every paragraph, every provision of this lease is material. So if you breach any provision of this lease agreement, it's a material violation of the contract, and we are entitled to enforce it with an eviction. So even if you paid your rent's hypothetically due on the 1st, it's usually late on like the 5th. If you pay your rent on the 6th, that's a breach of the lease agreement. Even if they accept the money, even if they say like, hey, you're all good and square, you owe no money, legally they can still file an eviction against you because your rent was late. If you have a lease agreement that says you have to have written permission for guests to come to the property, or the guest can't stay more than 7 days, or the occupant is this, or even some of the leases have language about being like respectful and courteous. Like, what does that really even mean? It's very subjective, but it's in a lease agreement. So if you're kind of upset because they've given you a notice on your door, you go in the leasing office, you're rightfully upset, but you raise your voice, and now the landlord's like, hey, I feel threatened, violation of the lease agreement. It's your word against theirs at that point, and more often than not, you're going to be evicted for that because it's a violation of the community standards that's in the lease agreement. So that lease agreement is everything. Those are the rights. Those are the things that you've agreed to. You've signed the contract. It's no different than when you sign a contract for your car, you sign a contract for your house. A contract is a contract. Trying to think. When you talk about representation in like justice courts, just know that you can represent yourself, or you can have an authorized agent, or you can have an attorney. Depending on their situations where you can have assistance from like a family member or somebody that's not getting paid. And that's just for the tenant representation. For the landlord, they have to have a property manager, an authorized agent, or an attorney. So you're not going to just have anybody just coming in, purportedly representing people in the eviction cases. During the pandemic, we actually saw a lot of these like companies that like emerge that was like, hey, tenant, you pay me $50 and I'll get your case reset. Or, hey, tenant, you pay this and, you know, I'll do this for you with the eviction process. And a lot of them were just scam artists. It was just taking advantage of people in a vulnerable situation because they needed time. And so there's nothing that these like agents or these different groups, I mean, I've come across plenty of people that have paid $200, $300, $500 for representation for a person that they never even met and a person that never even showed up in court. That's not even an attorney. Like an attorney might not even charge that much. But there's legal aid, so if I just know you don't have to go at it by yourself. But if you do, at least with this presentation, like when you get the PowerPoint, you can see the areas of like what you need to look out for, the things to be aware of, and you can actually advocate for yourself. With the eviction process, just know that you have the right to have a trial by judge or jury. More often than not, it's going to be a trial by judge. There's very few situations to where you might want a jury. I would recommend a jury trial. A lot of tenants want to be heard by their peers, but they don't really understand the jury process selection. So when you're thinking about a jury, you know, like we might be thinking about like some Law and Order, some like crime show that we saw. The jury is supposed to be a representation of your peers. But when you think about who's actually able to show up to a jury trial, it's likely going to be somebody that may not be hurting for money, because if I'm working hourly, I don't want to go miss work for a jury trial. If I'm on a fixed income, I'm not trying to like, you know, incur a cost by going to a jury trial. If they're not a registered voter, they're not going to be selected for a jury. And so your jury may or may not be a representation of your peers. A jury, they're going to be lay people for the most part. They might have like some type of specialized training or engineer, lawyer, doctor, but more often than not, it's going to be just regular people that have no special knowledge, that don't really care about the procedure. So if it's an eviction for non-payment of rent, they're not going to hear about, oh, but the ceiling was faulty and I had this agreement with the landlord, and because they're not going to hear it. All they hear is, okay, the rent was $1,000 and I didn't hear you say you paid $1,000, so judgment for landlord. So juries don't hear what you think they do. And so sometimes it is better, or in my experience, more often than not, it is better to go in front of the judge, simply because that's somebody that does it day in and day out. They have special knowledge and they can understand which procedures and things actually matter. But just so you know, you do have the right to a jury trial. If you can't afford the jury fee, you can file what's called a pauper's affidavit, a statement of inability to afford court costs, and that will waive that $22 jury fee. The jury fee does have to be requested at least 3 days before trial. So you can't just show up the day of and be like, I want my jury, because you didn't timely request it. For eviction cases, they're going to be held in the justice courts or justice of the peace courts, because that's the court that has original, like what's called original jurisdiction over possession issues. If there's a title issue, so if you have a situation where there might be like airship property, or there's a dispute about a foreclosure, or just dispute about, a dispute about ownership in general, that's not a case for an eviction. It's not a case for the justice court, because the justice court they don't determine title. If it's title, if it's ownership, no justice court. It has to be filed at the district court downtown at the main courthouse. Justice courts only have jurisdiction over possession issues. With these justice court cases, with the evictions, they do have jurisdiction up to, I believe, $20,000. I don't think that's a small amount of money to be kind of decided like willy-nilly here and there, but they do have jurisdiction up to $20,000. So if you have delinquent rent, it can be up to $20,000 plus court costs and attorney's fees if applicable. The other thing about evictions is that if you as a tenant are withholding your rent because of like repairs, it's important to know that eviction cases, you can't file a counterclaim. So it's not to say that you can't file a lawsuit against your landlord, but you can't do it as the defense in the same case as a lawsuit, as the eviction. So if your landlord files the eviction and you want to counter and say, no, I didn't pay my rent because my house was never fixed from the freeze, like I haven't had plumbing, I haven't had running water, my roof is caved in, there's mold, like why would I pay rent to stay here? None of that matters in the eviction case. that's where you would have to file what's called like a repair and remedy case. And that's a different lawsuit, different procedure, different things that you have to establish as a tenant. But you have to do that prior to the eviction case, because at that point it's probably too late. Because one of the main things about those repair and remedy cases where you're saying like my property was damaged or it's not habitable, or that I'm not paying for this property because it is not the value of what I was like agreed to in the contract, you have to be current on your rent. So by the time you come to an eviction case and now you're talking about the roof that's caved in and the leaky pipes and the water that doesn't work, more than likely you're not current on your rent at that point, which means that you didn't meet your requirements for the repair and remedy case anyway. But just know that there are no counterclaims. Really, there is no defense to an eviction for non-payment of rent. The only defense is to pay rent. So you can't say I didn't pay rent because, or I didn't do this because there's no defense. Now, if it's non-payment of rent, if it's a different issue other than non-payment of rent, of like, is it an unauthorized occupant? Did you have a pet? Was there criminal activity? Did you threaten the landlord? Like those are more like fact specific of did they happen or not? And it's just gonna be your word against theirs and who's more credible or what evidence you have. But with these cases for non-payment of rent, there really is no defense. Well, let me correct that. The one defense, quote unquote, is going to be if you like apply for rental assistance. And that's going to be a program that the county might offer. Now, it's a little bit different in Fort Bend, specifically because I know they have a different way of like allocating the rental assistance. And I don't know if the fund has been like, I don't know if there's more money available in Fort Bend. I know like in Houston or Harris County, there's more funds available. Especially like in surrounding counties like Galveston and Montgomery, a lot of those funds are long gone. So just keep in mind that you might be able to get pledges or donations or portions of your rent paid, and you want to get that in writing. Now, keep in mind, like the eviction, I want you to be knowledgeable. I want you to be informed. Evictions are about possession of real property. So it can be filed one time, it could be filed 10 times because it's only going to be about the right to immediate possession at the time the eviction is filed. So as a tenant, if you go through steps 1 through 3, you got the notice to vacate, you got the eviction citation, you had a trial, you got a judgment in your favor. That is wonderful. You have won, but it doesn't mean that the battle is over. The landlord can file an eviction, give you a new notice to vacate, you'll get a new eviction citation, you'll get a new court date. So just keep that in mind that you want to try to work with your landlord because it will be a vicious cycle that only ends in removing you from the property. Also keep in mind the only grounds for eviction is not non-payment of rent. Any breach of the lease agreement is grounds for an eviction. So again, unauthorized occupants, unauthorized pets, unauthorized guests, criminal activity, violating any provision of your lease agreement is grounds for an eviction. Let me see what else. The eviction petition, when that's going to be a document that's going to be attached to your eviction citation that you get from law enforcement. So I want you to make sure you use the correct terminology so that you don't get confused, especially when you're talking to somebody else about the case. The notice to vacate comes from your landlord. They can hand it to you. They can mail it to you. They can hand it to anybody at the property that resides at the property over 16. So don't get confused. Like if you have a babysitter, you can't just hand it to them because they're over 16. The person has to reside at the property. The other option is they can post it on the inside of the door. So I'm talking about you get the key, you open the door, you tape it to the inside of the door, shut the door back, lock it back. Those are like the options that the landlord has. And that notice to vacate is going to come first. So that's from the landlord. With the eviction citation, that's going to come from law enforcement. So a lot of people, unfortunately, the first time they hear about the eviction case is when they get the eviction citation. And so you want to be able to argue that, keep notes, keep documentation, take photos, take videos, document however you can what your landlord does or what notices they do give you. Because when you come into court and they're like, hey, I gave the tenant the 3-day notice to vacate on September 15th. And the tenant's like, I have no idea what you're talking about. The only document I got is from the officer. Then you want to do that. You want to make sure you look at your eviction petition, which should be attached to that citation that says, hey, the petition is going to tell you the grounds for eviction. It's going to have your name. There's simple things that can get an eviction case dismissed, like apartment complex, they put the wrong tenants because landlords can be a little bit lazy. And what they're going to do is they're going to recycle and copy and paste. And if they copy and paste the wrong tenant name or the wrong unit number, like you have possession of unit 123, but they copy and paste 125. You're not that's a whole different tenant. That's a whole different unit that they're trying to evict you from that you never had possession of anyway. So that's something to be mindful of. So you want to look at that eviction petition. You want to know it inside and out. You want to look at the grounds for eviction. You want to look at the amount of rent that they have pledged. You want to look at the notice to vacate because it's going to be in the eviction petition that says, I gave the notice to vacate on September 15th. It's going to have a manner of delivery. So they're going to say, I handed it to you. Some landlords will actually put it wrong on the eviction petition and say, oh, I emailed it to them, or I posted on the outside of the door. Like they'll put it wrong out there for you. And all you got to do is be prepared to argue it and know that that's not proper. Another big issue that we come across with these evictions and that what tenants should be mindful of or be aware of is who can actually file the eviction lawsuit against you. My mom has a house in Houston and she has a roommate, right? And I don't like my mom's roommate. So I'm like, you know what, I'm gonna protect my mom. I'm gonna go file the eviction to get rid of her roommate. Like, who am I? I mean, that's my mom, but I can't file the eviction to remove somebody from property that I don't have any type of relationship with outside of like knowing them. So if I don't own the property or if I don't have a lease agreement with the tenant, I can't just go file an eviction case against you. Similarly, like when you're dealing with like heirship property where there's multiple heirs that own the same property, you can't evict another heir from the property because you all have an ownership interest. You can all stay there if you could, amicably make it work. So if there's 3 heirs, 3-bedroom house, and all 3 want to be there, you just can't go evict the other one. So look at the name of the person or the entity, the business that's listed as the plaintiff, because you want to see if that name either matches the owner of the property, which most times it's not going to have like the actual owner of the property, or if it's going to match the name of the landlord in your lease agreement. So if your lease agreement says that the lease is between you and 123 LLC or between you and Stratford Place Apartments, and the lease, the eviction petition has something about Horizon on Park, you're like, I don't even know who that is. They can't evict you from something that's not theirs. So you want to make, good note of who actually is filing the eviction lawsuit. Sometimes landlords will evict you in the name of the property. It gets a little bit in the weeds there because if a landlord doesn't have a DBA or doing business as, technically it wouldn't be proper for Stratford Place Apartments to evict you if Stratford Place Apartments doesn't technically exist, because the owner of the property might be Stratford Place Apartments LLC, and that LLC changes everything. Or if it's a LP or a corporation or any type of, like those business entity or business designations matter. So they can't just leave it off because it matters. So those are things that you want to look at with trying to like represent yourself, or things to just to be on the lookout for with these eviction cases. Another thing that I want to just kind of touch on is just the difference between an eviction and a non-renewal, because a lot of tenants get it mixed up. So an eviction, landlord files the eviction based on some lease agreement violation. Didn't pay your rent, unauthorized occupant, unauthorized pet. I'm using your violation as grounds to remove you from the property. Now, when you're dealing with a non-renewal, that means that your lease began on, let's just say, January 1st, and your lease is set to end on December 31st. And on 3 months, October 1st, your landlord gives you a notice that says, hey, I don't want to renew your lease agreement, so effective December 31st, it's done. There's no more lease between us. If you look carefully at your lease, a lot of leases contain language that say there's an automatic renewal of the lease agreement. And so I'll get in court all the time. I hear judges say it, I hear tenants say it, I hear landlords say it. Well, they'll be like, oh, judge, there's no lease agreement between the parties. And I'm like, well, that's not true, because the tenant's on a month-to-month lease. A month-to-month lease is a lease. It's in the name, month-to-month lease. And so if your lease agreement has expired on December 31st or whatever date expired and you didn't give notice, or your landlord didn't give notice that you didn't want to continue that lease, you can be a month-to-month tenant forever. So know the difference in notice of non-renewal and a lease, an eviction are two different things. As a tenant, you want to know, because I've had tenants I've represented on this issue as well. As a tenant, if you plan to leave that property, look at your lease to see how many days notice you need to, how many days notice you have to give. I mean, I'm not shameful to say, before I went to law school and I came to Houston from Huntsville, and I came from a smaller town where you gave 30-day lease, like you gave a 30-day notice that you were leaving. And so at my first apartment, I gave a 30-day notice and thought life was good. And then they hit me with like this big bill, like, hey, you can leave in 30 days, but you're gonna have a broken lease. And I'm like, how do I have a broken lease? Because I gave a 30-day notice. They're like, well, your lease agreement says you have to give a 60. And I was like, no, it doesn't. I mean, I was younger, and didn't read the lease, because who does that? Like, who reads lease agreements? Like, I'm just gonna live here and life's gonna be good. And I actually had to renew my lease to give proper notice so that I didn't have to have a broken lease. So if your lease requires a 30-day, a 60-day, a 90-day notice, you want to make sure that you calendar that and give the proper notice, because if you leave with not sufficient notice, you have broken the lease agreement, and now you're going to end up owing money, and it's going to be a lot more money than you anticipated. I can guarantee you that part. As a tenant, this is like, it's an important topic to talk about, like with retaliation, because I hear the word thrown around a lot. And so retaliation doesn't necessarily mean what you think it means in eviction world. So there's like the Texas Property Code, it actually defines retaliation and it defines non-retaliation. If you're late on your rent and your landlord takes some action against you, no retaliation. It's only going to be retaliation if your landlord is going to be, if they actually say it, which nobody ever does. But if they don't renew your lease agreement because of like your race, your gender, your ethnicity, your religion, something of that nature, or if they take any type of action against you because of like a protected class, then we're talking about violations of fair housing and retaliation. But if that's going to be one thing to keep in mind. If you're a tenant, which we don't really have a lot of tenant organizations, but if you like form like a tenant organization where you collectively kind of have like a mini union at your apartment complex, where you go about and you try to organize the tenants, and your landlord takes adverse action against you, then we're looking at retaliation. If you report, like belief, a good faith report that there's like building code enforcement or housing code violations, that will be retaliation. But if you report that after you're delinquent on rent and then your landlord files an eviction, it's going to be a little bit gray there if that's retaliation or not, because it's not retaliation if you're not current on your rent. There's a lot of things that aren't considered non-retaliation. So if you look at your lease agreement, you're going to see there's all sorts of like increasing the rent clauses. There's acceleration clauses. And I actually saw this yesterday in court, where the landlord said like tenant was behind 1 month. And they're like, hey, I got the money today, I'm gonna pay it, and it's gonna be great. The landlord's like, no, it's not just 1 month rent. We accelerated your rent, which means that you have to pay all the rent that's due remaining in the lease agreement in order to avoid the eviction judgment. And they're like, but why would you do that? And it's like, because it's in the lease agreement and they can't. And so your lease agreement has rent increases, there's no percentage, there's no amount. As long as they give you a 30-day notice after your lease ends, it says, hey, your lease was $1,000 during the initial lease term, but if you're going to stay here month to month, it's going to be $2,000. No violation there. There's nothing to stop them from, and there's no rent control laws in Texas at this time. So just know that there's a difference between retaliation and non-retaliation. I'm trying to think what else would be helpful. I don't know if I can change the screen to see if there's anything in the comments. Oh, I can make it smaller like that. Oh. Does it still work? Yeah. Oh, okay. I'm trying to think. I just want to emphasize, like, time and time again, eviction is about possession. Notice to vacate comes before the eviction. Eviction citation comes after the eviction is filed. As a tenant, this is something that I would like to share. If you get a notice to vacate and it's a 3-day notice, and let's just say you vacate on the 4th day, but the eviction case hasn't been filed yet. If the eviction case is subsequently filed after you vacated the property, you're good. The eviction case is not proper, it can be dismissed. The only question it's going to be is if you ever get notice of that eviction, because so you want to monitor, as best you can with some of the online public records, because a lot of landlords will get an eviction against the tenant that actually vacated the property. If you vacate after the eviction case has been filed, meaning like after you receive the eviction citation, after the landlord's paid the fee to the court, and then you vacate, an eviction case can still go forward, a judgment can still be entered against you, a judgment for money can still be collected. So if you do anticipate vacating the property to avoid the eviction, you have to do so before the eviction case is filed. If you vacate after the eviction, it can still go forward. Now, like, just to kind of digress for a second, because of like some of the things that happened in the news recently, dealing with kind of self-help evictions. So in self-help, like to kind of paint the picture for you, like I see a lot of movies like in New York and stuff, where the tenant will be walking down the street, or I don't know if what they call like the brownstones, and they'll see people's stuff outside, be like couches and TVs, and it's all ransacked, and it's just outside the front of the unit. And the tenant comes home from work, they're completely blindsided, their stuff's outside, it's already been ransacked. That right there would probably be what we call a self-help eviction in Texas. There's no situation to where the landlord can remove the tenant or the tenant's property from possession of the unit without an eviction case. If you file an eviction, if you don't file an eviction case and you take steps to remove the tenant physically or maybe even constructively from the property by kind of like threats or threats of force, or like the one in the news recently with the guy that would show up with like the big menacing dog that says like, hey, if you don't want my dog to do something to you, you better leave. Those are all self-help evictions. If the landlord does anything to remove you from that property without an eviction case, self-help, illegal, and there's a lot of penalties attached to it. I'm going to stop for a second because I see a question. Are the apartments, is it mandatory to give in writing rent increase? It has to be 30 days. That's going to be kind of more specific to your lease agreement, but generally, if your lease agreement has an increase clause, they have to usually give at least 1 month's notice before that increase takes place. So usually it's going to be a 30-day notice. In your lease agreement, it could be that they say, hey, it's effective upon delivery. You get 1 day's notice. But if your rent has been $1,000 all the way through, and then it just jumps up to $1,500, typically it's not going to be permissible without notice, because that month-to-month lease renews everything as if like the initial terms of the lease. The only thing that changes about that lease is just the time frame. And you just have like 12 mini leases instead of one 12-month lease. But yes, I would say that typically it has to be 30 days notice. And so if they give you a 30-day notice, that it goes up $25, and they give you another 30-day notice, it goes up $50, and they give you another 30-day notice, it's going to go up $500. At that point, it's up to you if you're going to stay and pay it or not. So just review that portion of your lease, get a copy of your lease if you don't have one, because that's probably going to be addressed in it. If it's not addressed, then 30-day notice is required, or at least 1 month's notice is a better way of saying it. I'm going to say a lot of this, I guess, remaining of the eviction presentation is kind of touched on in the PowerPoint, but there is a Supreme Court order in place right now, and it's called Emergency Order 54, and it deals with rental assistance, and it's called like the Texas Eviction Diversion Program. So if there's available rental assistance in your county, in your area, and you and the landlord both agree to participate in this rental assistance program, then there's a rule from the Supreme Court of Texas that says, hey, we're going to put your case on pause for 60 days so that we can give the rental assistance time to pay. At the end of that 60 days, in theory, the rental assistance should have paid. And it's a way to kind of like divert the eviction case so that the landlord gets paid, the tenant doesn't have to have an eviction on their record. And then another really cool feature about this process is that your eviction case is actually going to be placed in confidential status and it's going to be sealed so that there's no public disclosure. I talk to a lot of tenants that tell me like, hey, I'm like, what are you hoping to get from this? They're like, I want to avoid the eviction. And I have to tell people time and time again, unfortunately, the damage is done with these evictions as soon as it's filed. As soon as it's filed, it's a public record. As soon as it's filed, it can be on your credit report. All anybody cares about is the filing of it, because that's what's gonna show up. And then the other thing with these eviction cases is that you have like your credit report with like TransUnion, Equifax, Experian, like your federal consumer public like credit report. And then there's this, and so that's something that you can't control. And so it's kind of like buying an app for 99 cents or $2.99 on like App Store, Google Play, Play Store, whatever it's called. It's just a private app that landlords use to say like, hey, is this tenant credit worthy? Should I rent to this tenant? And so those are things that you can't control. And that tenant screening, that private tenant screening report is what messes up a lot of tenants. Because even though, and like even from my personal experience, with my first apartment in Houston, I actually got an eviction notice on my door. I was freaking out because I actually paid my rent. Went to my landlord and said, hey, like, what's this about? Because like most tenants do, they talk to the landlord. They think that everything's okay. Talk to my landlord, they was like, we're so sorry, wrong apartment number. It was actually supposed to be for like your downstairs neighbor. So like I was on the third floor. It was supposed to be for like whatever the unit was on the second floor. So I was like, oh, okay, cool. But the note I got on my door was actually the citation from law enforcement. So I took that to the officer. To my landlord and was like, hey, thought everything was copacetic. It was worked out. Didn't go to court because my landlord said it was okay. What happens? The case actually was dismissed against me because I didn't go to court and my landlord didn't go to court. But even after I got that dismissal, for 7 years, I had to explain why I had an eviction case filed. I had to take a copy of my judgment with me to every apartment I went to after that initial case, even though I was never evicted from the property. And so that's just how powerful, that's how deep these eviction issues run, is that even if you do win, you still want to get a copy of your judgment, or you want to try to work to have some type of agreement to have it released, because they follow you and it's hard to get better housing after an eviction case is filed. So at that point, one of the best things that we can do is try to work towards a dismissal. So at least that when you do go to a new property, we can say, yes, an eviction was filed, but it was dismissed. Like you don't want to be in a situation of where even though, the case was filed, you got a judgment and now it's going to be like any other kind of principle in life. If, you borrowed money from Peter and Paul knows you paid money, like you owe money to Peter, they're not going to give you any money to lend either. Because like, hey, you never paid Peter back. So why would I put myself in the same situation and give you money knowing that you don't have a good history of that? And so with our office, we work really hard with trying to negotiate dismissals. Sometimes they do require like quick turnarounds with the tenant vacating, because most of the time these properties aren't after money when they file the eviction case. They're trying to get possession of the property back because they're volume based. So if you're not paying, if I can get somebody else that's going to put a deposit down first month, last month, whatever the deposit is, like that's money that they're able to get in. So the sooner I get this person out that's not paying, the better, because I can now get somebody else in that's paying. And so those are some of like the strategies we use to try to put tenants in a better situation of avoiding eviction judgment and being able to move forward in peace. But just know that with that Texas eviction diversion program with the Supreme Court of Texas, if you're not dealing with a non-payment of rent case, or if you're not dealing with, or a non-payment of rent case that's dealing with like a statewide rental assistance program, then you're not going to be able to get your case sealed or put in confidential status or anything like that unless you negotiate that with your landlord. And sometimes I'm able to agree or get the landlord to agree to seal the case, because there's a lot of power in that case being sealed, because now it's no longer a public record. The other thing that comes along with these eviction cases is going to be writs of restoration. I'm sorry. Yes, writs of restoration and writs of reentry. So a writ of restoration is going to be, hey, the short way is my landlord disconnected my lights, my landlord disconnected my water, they disconnected my gas because I didn't pay the rent. The short answer, landlord can't do it. Unless it's a bona fide repair and they say, hey, some truck just hit the water line and we had to cut everybody's water off to make repairs, that's fine, because I mean we got to fix it because there was some unforeseen act that took place, or we have some scheduled maintenance going on, so you're going to be without lights for 6 hours, and we try to do it while you're gone at work or something. But if your landlord's like, oh, by the way, you didn't pay your rent, so I'm going to cut your lights off, or I'm going to interfere with your gas or interfere with your water, as a tenant, you do have a remedy against that, and you can file a writ of restoration with the justice court. And in that lawsuit, it's actually what's called an ex parte proceeding, which means it's just going to be you and the judge. And you're going to tell the judge one-on-one, like, hey, I know I didn't pay my rent, but my landlord cut my lights off. And look, like, my bill is current, my light bill is current at least, or they've taken some type of action to disconnect my lights and it's not proper. So judge, I need you to have law enforcement go out and tell my landlord to cut my lights back on, to cut my gas back on, to cut my water back on. And then after that ex parte hearing, it's actually going to be set for a subsequent hearing to see if the landlord complied and if that landlord actually had a good reason for disconnecting the utilities. If they don't, there's major penalties and fines associated with that. Same thing with, well, it's a little bit different with the writ of reentry. So in Texas, we have like this really strange law. I remember hearing about it in law school, and I thought it was like a really stupid law, actually, when you're dealing about with locking the doors or changing the locks. Like, for the life of me, I sat in my property law class, and it made no sense to me why your landlord can change your key, like change the lock to your door, and then give you a key to the new lock. Like, why would you waste the time and energy of changing the lock only to have to give the person a key? So in Texas, if you are delinquent on your rent, your landlord can change your lock. So don't be surprised. They can prohibit your ingress or egress into the unit. But the purpose of it, now that I'm more mature and understand, is to kind of force the tenant to come into the office to discuss the delinquent rent. Because sometimes you have tenants that they don't want to talk to the landlord. They kind of like stay out the way, or they might duck and dodge, or they put note, the landlord's like, I put notes, I came by, they never answer. And so what do? I change the lock because it forces the tenant to come and get a key from me. And when I'm coming in that midst, in the midst of you coming to get the key, now we're going to talk about it. Now, there are some restrictions on how your landlord can change the locks on the property. They do have to give you notice about it. They just can't, say like, hey, by the way, your locks are changed, and that's fine. Like, you can't get in. What do you want me to do about it? Should have paid your rent. Not permissible. The law actually does say that the landlord has to post a notice on the door. They have to tell you where you can get a key at 24 hours a day. And if the office, it's going to be available in the office. So for instance, if you come home from work after 6, after the property office has closed, there has to be an on-site number that you can call that's going to have that key delivered to you within 2 hours. So I don't care if it's 1 a.m., 3 a.m., 6 a.m. If they change the locks on that door, they have to give you a key. So generally, just know it's only going to be for non-payment of rent cases where they can put a notice on your door and say, hey, I changed the locks because you're delinquent on rent. But for any other reason, like I just changed the locks because I don't like you, or I changed the locks because, I don't even know what reasons the landlord might change the locks, but there are some kind of petty landlords that try to force the tenant out, which would be kind of what we call a self-help eviction, because they're trying to force you out without actually filing the eviction case. So they want to make it uncomfortable for you so that you self-evict by voluntarily vacating the property. And so they do little things like this to try to pick and poke at you so that you as a tenant just get fed up and leave. But just know you're right that they can't just change the locks and not give you the key. They can't just cut your water off and not have a reason why. So that, there's not a lot of rights for tenants when it comes down to property, but this is one big one. So don't be intimidated. Don't be scared. Like, you have the law on your side on this, and the landlord is liable for damages of, I think, 1 month's rent, a $500 civil penalty, and any actual damages that you might incur. So if you have to get a hotel room because you called your landlord and they didn't bring a key for you, or if you are on medication that's locked in that property, and now you have to go order or get another prescription or something, or you have to go pay anything out of pocket you have to pay after being unlawfully locked out. Like those are things that you as a tenant have the right to enforce. I'm trying to think. Oh, and then another kind of like weird thing that happens in some lease agreements, which I haven't come across a landlord actually exercising this right, but the landlord does have the right to seize your personal property if you're delinquent on rent. And it has to be in your lease agreement. It has to be like underlined or bold or put someplace where you can actually see it. And so like if you're delinquent on your rent and you have this clause in your lease agreement that says that your landlord can seize your personal property, then they can come in and say, hey, tenant A is delinquent on rent. I came to the property. I'm going to leave a note of everything that I took, and anything that's not exempt, they can take as I guess a debt towards your delinquent rent, or as credit towards your delinquent rent. So like an Xbox, PlayStation, your collections of Pokemon cards, like anything like that that's personal property that is not an exempt status, landlord can use to seize towards the delinquent rent. There are like some exempt properties, because like we're in Texas and we have a very long list of exempt personal property. So like they can't take your food, they can't take your family heirlooms, they can't take your clothes, they can't take 2 firearms, they can't take anything that you use for a trade. So like if you're a blacksmith or a welder or a carpenter, they can't take your tools. They can't take your motor vehicle if it's like your only vehicle or something of that. So just know that that provision is typically in some lease agreements, but I've never actually seen it exercised. With some of the rental assistance resources, usually like Google is like one of the best ways to find it, or calling 211. I think it's 211 in Fort Bend County as well. But there's not a whole lot of rental assistance resources like on the statewide level at this point. But like there's churches, nonprofits, and different community organizations that offer rental assistance like on a smaller scale. So they may not be able to say like, hey, here's $5,000 all at once, but they might be able to give you 500. And smaller amounts from multiple places adds up. And so don't be discouraged if you can't get the full month's rent, because you might be able to get it from multiple places. And I think just keep in mind, like if you're going through the eviction process, it is a stressful process. And it's going to be life happening all at once, because either everything's happening or nothing's happening. And so like with the eviction process, like I've had tenants say, hey, I'm getting evicted, I lost my job, my car is getting repossessed. Like it's like everything is crashing in and happening at once. And it can get overwhelming to the point to where tenants are like, you know what, forget this case. I just don't even want to go to court, or I just don't want to acknowledge the existence. And so I know it's very hard to try to prioritize a lot of competing interests, but just try your best when you're dealing with evictions to just say like, hey, okay, this one has like a 21-day turnaround versus this problem is like a 60-day turnaround versus this one's like a 6-month problem, because it's going to be too much to handle all at once if you don't find a way to try to like compartmentalize and address things like as they become due. It moves quickly, so you don't want to wait to reach out to legal aid resources. Like it's the Earl Carl Institute. You can reach out to Lone Star Legal Aid. I'm trying to think who else is in this area. I think those are the main two actually. And there's actually state bar. If you look at the state bar attorneys page, there's even attorneys from the state bar that will take cases pro bono, no fee to you, but you have to like do the initial legwork of like reaching out. You don't want to wait till the last minute, because I can't tell you how many cases I get the day before where the tenant's like, hey, I'm getting evicted tomorrow, or my trial's at 1 p.m. and they reached out at 9 a.m. the day of. And so as soon as you find out about it, as soon as you get that notice to vacate, if you don't get the notice to vacate, as soon as you get that eviction citation, like start making calls, start reaching out, start making the connections, and create a paper trail. If you're working with your landlord, I'm not going to say all landlords are bad, because they're not, but you do want to make sure that you are smart and protect yourself in this process. If you come to an agreement with your landlord, get it in writing. Even if you can't get it in writing, have a witness. If you can't have a witness, at the very least, record it. Because I mean, in Texas, we are a one-party consent state. So I mean, if it comes down to it, I mean, I'm having a conversation with John here, and I was like, hey, John, we're having a conversation. I'm like, I give myself permission to record, and that's all I need, because it's, you know, one party. Now, be careful if you're doing recordings over the phone, because you have to be fairly, like, you have to be confident that the other person you're talking to was in a one-party consent state. Because at that point, if they're not, now you're violating federal wiretapping laws, and I don't even know all those statutes, but I know you don't want to do it. So if it's one-on-one conversation in person, do it. Take it in writing, memorialize conversations. Hey, apartment manager, I just left the office. We discussed this. I want to make sure that my understanding of this is correct. This is our agreement. Can you respond back to let me know? Because I can almost guarantee you a landlord will make all sorts of agreements with you. And then what happens? The property's sold. You have this relationship with the one property management, and you have this agreement that was going, and it's been like a 2-month or 3-month or 6-month agreement or something. Property sales, new landlord or the new property management has no idea who you are. They don't really care who you are. And now they're filing an eviction case for an agreement that you had or that you thought you had. So put it in writing. I mean, I can't say anything. Put it in writing. If you come home and you see something flying on your door, take pictures. I mean, I can tell you, like, representing tenants, like, I love those Ring cameras. Like, those have become like very, very, I mean, it doesn't get any better than that when the tenant has like a Ring camera. I'm not saying go get a Ring camera and protect yourself, but it doesn't get any better than a tenant that has a Ring camera showing that the landlord posted the notice on the outside of the door. Because how else do you defend that? Like, I got a video of you saying you did exactly what you did, and here it is. So that's just some best practice strategies to just keep in mind. Documentation is key in all aspects of life, but especially with court. So I think that's about it for the presentation. I can get it emailed out to you, and I'll pass it over to.
No, I just want to say first, I'm sorry for the technical difficulties, but even despite those difficulties, I think Stormy came in and gave us a really excellent presentation. You can tell this is something that she's dealing with all the time, and you know, she gave a lot of the practical realities of things, you know, the time frame thing and so forth, and just sometimes the lack of defenses that, you know, the tenant's going to have. You know, it's a hard thing, and it's something that we deal with here as well. And you know, you can tell that Stormy is somebody who's just dealing with this all the time and really knows what's going on. And this is the best eviction presentation I've been a part of. And I've been a part of a few of these over the years that I've been a law librarian here. So I think the PowerPoint's going to be helpful to y'all when I send it out to you. And you know, I think Stormy can be a resource for you going forward and so forth. So
yeah, we represent in Fort Bend County as well.
Yeah.
At the Earl Carl Institute.
You know, we've got a long, you know, I've been here for 5 years at the law library. You know, we've got a pretty long history with Earl Carl. Before the COVID stuff came along, they were coming in and kind of having office hours here at our law library every now and again, and maybe we'll get that going again, hopefully. You know, they're a real great institution, and they're part of our go-to that we refer people to, kind of our group of. It's not a big group, but there's a group of core institutions and organizations that are out there designed to try and help people when they're at their most vulnerable. So just really want to thank her for her excellent knowledge, and we'll try to see. I saw one question, you know, more webinars with Earl Carl. We'll see what we can do about getting them back out here maybe again in the next few months to touch on this topic again, and maybe have someone who's a little more tech savvy than I am running things. But anyway, thank you everybody for attending and for the time you gave to us and attending, and to Stormy for coming out here on a Friday afternoon as well. So thank you so much.
Thank you for having me.
Gotcha. Appreciate it, y'all. All right, folks. So I'm going to sign off.